Concept of crime. Topic: classification of crimes. Systems divide crimes into categories for various purposes connected with the procedures of the courts, such as assigning different kinds of court to different kinds of offense. Common law originally divided crimes into two categories: felonies, the graver crimes, generally punishable by death and the forfeiture of the perpetrator's land and goods to the crown, and misdemeanors, generally punishable by fines or imprisonment. The procedures of the courts differed significantly according to the kind of crime the defendant was charged with. Other matters that depended on the distinction included the power of the police to arrest an individual on suspicion that he had committed an offense, which was generally permissible in felony cases, but not in misdemeanor ones. See felony and misdemeanor. By the early 19th century, it had become clear that the growth of the law had rendered this distinction obsolete, and in many cases it was inconsistent with the gravity of the offenses concerned. For example, whereas theft was always considered a felony, irrespective of the amount stolen, obtaining by fraud was always a misdemeanor. Efforts to abolish the distinction in English law did not succeed until the late 1960s, when it was replaced by the distinction between arrestable offenses and other offenses. An arrestable offense was one punishable with 5 years imprisonment or more, though offenders could be arrested for other crimes subject to certain conditions. Subsequently, further classifications were devised. For example, a subcategory of serious arrestable offenses was created, and, in order to determine more easily the court in which a case should be tried, a different classification of offenses into the categories of indictable, either way, and summary was adopted. Nonetheless, the traditional division between felony and misdemeanor has been retained in many U.S. jurisdictions, though there has been a rationalization of the allocation of offenses to one category or the other, and it has been used as the basis for determining the court that will hear the case. In some jurisdictions, minor offenses were classified under a new category called violations, which corresponded broadly to the English category of summary offenses. In systems utilizing civil law, the criminal code generally distinguished between three categories: crime, delete, and contravention. Under this classification, a crime represented the most serious offense and thus was subject to the most severe penalty permissible. Deletes were subject to only minor prison sentences, and contraventions were minor offenses. Beginning in the 19th century, some civil law countries, e.g., Sweden, the Netherlands, Brazil, Portugal, and Colombia, consolidated their codes. Deletes were reclassified under the broader category of crimes, and contraventions came to denote criminal offenses committed without intent. All types of criminal codes account for a variety of crimes, including those generally committed by individuals or unorganized groups, as well as other modes of criminal activity. For discussions of particular crimes and types of criminal activity, see arson, assault and battery, bribery, burglary, child abuse, counterfeiting, cybercrime, drug use, embezzlement, extortion, forgery, fraud, hijacking, homicide, incest, kidnapping, larceny, organized crime, perjury, piracy, prostitution, rape, robbery, sedition, smuggling, terrorism, theft, treason, usury, and white-collar crime.